Good afternoon, everybody. My name is Kristen. I head sales and partnerships from our Brisbane location. Thank you for joining us today. We have several guests who have joined this session virtually, so I'd like to take this opportunity to briefly introduce you all to Clarence. Clarence has been supporting the legal profession for over 30 years, operating across Sydney, Melbourne, and Brisbane. We've built our services around the needs of lawyers and are proud to support over 600 firms nationally in starting, running, and growing their own practices. Now, I'd like to introduce you to today's presenter. Stephen Page is a legal practice director of Page Provan Brisbane. A father through surrogacy, Stephen has advised in over 2,000 surrogacy journeys for clients throughout Australia and in 39 countries, and is Australia's preeminent fertility lawyer. He was admitted in 1987 as a solicitor and has since 1996 been an accredited family law specialist. Stephen is a fellow of the International Academy of Family Lawyers and of the Academy of Adoption and Assisted Reproduction Attorneys. He is a member of a number of committees, including being an international representative on the ART Committee of the American Bar Association since 2012 and Secretary of the Fertility Society of Australia and New Zealand. Stephen has received a number of awards, including inaugural Pride in Law Award 2020 and Queensland Law Society's President's Medal 2023. He has presented and spoken widely and has authored When Not If, Surrogacy for Australians and International Assisted Reproductive Technology. Now over to you, Stephen.
Thank you, Kristen. And unfortunately, we don't have the camera, or maybe that's fortunate for everyone at the other end. They don't get to see me. I'm speaking from the lands of the Yago and Turrbal people in Brisbane. So I'm going to start. I've got a lot of slides to go through. Because we're doing it remotely, I just asked that if there are any questions, put them in the chat, and we'll try and fish them out by the end if there's time. If not, I'll follow up with whoever's asked a question later. So that's me. So you can see why I'm just going to move on with no camera and immediately move on to the thinking in our law about who is a parent. So when I'm talking about a parent, I'm talking about legal concept. I'm not talking about biology, although biology, of course, is often tied up in it. And the thinking since the time of the Emperor Justinian, who's depicted here, is the mother is always certain, because the mother gives birth. And we have this statement in Latin, if anyone is interested, but that's what it means, the mother is always certain. So the thinking about the law since the 5th or 6th century has been about who is the father, not about who is the mother. And that then has led to complications much more recently with the rise of IVF and surrogacy, because the woman who gives birth may not recognise herself or may not be recognised by others as the mother. And so we've had this focus about who is the father, or as put on that sign, who's your daddy? And as the High Court said, a finding that a particular man is the child's father might well be of greatest significance to the child in establishing their identity. And really, I thought the High Court judges nailed it on that point. And here this slide is about technical things about assisted reproductive treatment. I'll just give you this timeline. So we started sperm donation in the 60s, early 70s. Australia has really been a leader with IVF technically, and we see that the third in the world was Candice Reed, born in 1980. The first donor egg used was in Melbourne, internationally in 1983, and the following year, first birth from a frozen embryo transfer. And from a technical point of view, most IVF that is now occurring where there is a implantation of an embryo is the frozen embryo transfer, not fresh. We had our first gestational surrogacy birth in 88. My first surrogacy case was the same year, 1988, but it was what's called traditional surrogacy, in that the surrogate was the genetic mother and became pregnant, I presume, from an at-home insemination. And then by 1992, it was the first use of intracytoplasmic sperm injection, or ICSI, and that's what the picture on the right is showing. This is the dominant form of IVF these days. When we think about IVF, we think of a petri dish. We put the egg in the petri dish and we squirt the sperm around, maybe 200,000 sperm, and one of those will pierce the skin of the egg, and then fertilisation and embryo will be created. However, men certainly have had a loss of fertility over the last 50 years, and ICSI was devised as to cut off the head of the tail of the sperm and pick an individual sperm and implant that, pierce the egg with the needle. And it now represents about 60% of all IVF that's occurring in Australia, and that's consistent with international trends. And the last one, consistent with Australia and New Zealand having jointly the lowest maternal mortality rate in the world as an area. We've been really keen, Australia and New Zealand IVF clinics, about minimising risk, and the way that they've done that is single embryo transfers. So if you only put one in, there's much less chance that you're going to get multiples coming out. And of course, if you have multiples, therefore you have greater risk for the woman and greater risk for the kids. And the other thing that's been happening at the same time, of course, is the rise of DNA testing reliability. And this really came about in the early 90s. And so we had this case of G&H that I've quoted before in the High Court, which was this heterosexual de facto relationship. He was a postie, she was a sex worker. And she said, "You're the father of my child." And he said, "Well," because it's a child support issue. "Well, no, I'm not. You have sex with everybody." And she said, "Well, no, she had sex with lots, but with him, she was the only one that she had unprotected sex with. With everybody else, it was using a diaphragm and a condom and a spermicide." And so the High Court said, "Look, it's scientific certainty now about who's a parent. DNA takes it that far, and he would know it. This man would know it. And because he's refused to undertake the test, therefore we can draw the adverse inference, your dad." And the legal responses to donation started as long ago as 1980, and this communique by the Standing Committee of Attorneys General. And we've got this phrase that, well, it's the husband, not the donor, who's the parent. And the next phrase, the sperm donor shall have no rights or liabilities in respect to the use of the semen. And the child should have no rights or liabilities in respect to the sperm donor. So this phrase, no rights or liabilities. Well, thankfully, that language is not used anywhere now but Queensland. It was also in the Northern Territory Status of Children Act, but I got it taken out of there when the Territory enacted a Surrogacy Act about 4 years ago. Because in Queensland, we have it in provisions such as Section 23 of the Status of Children Act, where the genetic father is still a parent, albeit with no rights or liabilities, according to Justice Tree in this case. Now, Lamb and Shaw was a surrogacy arrangement that went awry, and so there was this standoff between the intended genetic parents and the single surrogate. There was then an appeal, at which point the appeal court said, well, it's unclear whether she was in a de facto relationship with the surrogate at the time of the birth, so we're remitting it. So it went back to Justice Tree, who had previously determined it, to look at that question again, at which point the surrogate said, surprise, I wasn't in a de facto relationship at that time, but nevertheless there was a second determination. But that decision, or those decisions in Lamb and Shaw, didn't sit well with how the Surrogacy Act worked in Queensland. Justice Tree saw that there was a difference between the Surrogacy Act and the Status of Children Acts, and neither of the twain should meet. What he hadn't been told by the lawyers in the case was that the particular section he was looking at had been amended by the Surrogacy Act. And there was the other issue that under the Queensland Status of Children Act, if you've got a lesbian couple who are living in a de facto relationship, then they are recognised as the parents, and the man who provided his sperm had no rights or liabilities. So is he going to be a third parent? But at the same time, the Surrogacy Act amended the then Births, Deaths, Marriages Registration Act that said only two parents in the birth certificate. So Parliament was making it quite plain that a donor was not to be a parent. And hence this decision in which of RBJ and MMJ, in which I was for the intended parents. So we have Status of Children Acts, and NI doesn't stand for no idea. It stands for Norfolk Island. I had no idea that Norfolk Island had a Status of Children Act until I went to prepare this presentation. Lo and behold, they do. There's all about 2,000 people living there, so not many. And in case you're interested, because I looked at Norfolk Island, I thought, what about Cocos Keeling Island? How they included? Well, they're included, and Christmas, they're included under Western Australia. But there we go. Each state has a Status of Children Act or similar name. WA has the Artificial Conception Act and its own Family Court Act, but the former is to be repealed by the passage of the Assisted Reproductive Technology and Surrogacy Act. That was enacted a week before Christmas, but it doesn't take effect until mid to late next year. So, what's the general scheme? Well, there's some general parentage presumptions under this Act, reflecting those under the Family Law Act. And otherwise, if there's a donation and the husband or partner consented, then the couple are the parents and the donor isn't. And the problem is that we have this schizoid system that if you have state proceedings, you've got to look at state laws, but then keep one eye on the back of the fence about what's the Family Law Act say. And the classic example is if you've got a surrogacy proceeding, as you can see there in Section 17 of the Queensland Act, you go under the Queensland provisions. In this case of SVB and OVD, the intended parents were two couples, and in each case, the man was put on the birth certificate as the parent because he was the biological parent. Problem, he wasn't recognised as a parent under the New South Wales Status of Children Act, and that then caused a whole world of grief until a judge let it go through as an exception. But they had to then convince the court that, well, he might have been named there, but still please let it through. So if you've got state proceedings, surrogacy proceedings, you do not put the name of the intended parent on the birth certificate. Otherwise, you're going to have a whole world of pain. You put on who is recognised under the state proceedings as a parent. And now we've covered state law quickly, we look at federal law. And the problem is that there's no consistent definition. That's with one exception, and that is if you get a declaration under Section 69VA of the Family Law Act that someone is a parent, then that is conclusive for all federal laws. You can't get one of those unless you've got some other proceeding on foot, for example, about parental responsibility, where a child lives, or parentage testing. You can't go to the Federal Circuit Family Court of Australia just for that declaration. If you merely want to get a declaration, you go to a state court, for example, the Supreme Court of New South Wales or the Supreme Court of Queensland. And you might think, well, that's pretty straightforward, but then examples of the inconsistency, you can see there that DFAT views a foreign surrogate as the mother because she gave birth. It doesn't matter that under foreign law that she's not a parent, and indeed it doesn't seem to matter that under Australian law, when you look at parentage presumption, she's not a parent, they still take the view that she's a parent. And it doesn't matter that you might have a court order that says she's not a parent, they'll just ignore that. I'm getting puzzled look, but I can tell you that that is the reality of dealing with DFAT. It is really quite extraordinary. Because she gave birth, the mother is always certain she gave birth, therefore she's the mother. It might also be because they've looked at Section 60H2 of the Family Law Act, which I'll come to. And who's a parent for the question of citizenship by descent is a question of fact, and it's not limited to a biological parent. So if you have an intended parent who wants to go overseas for surrogacy, who is not going to be the biological parent, and they're the only one who is an Australian citizen, then they need to get advice first before they go on their journey, because it can turn into a world of pain if they're not careful. And this call out from H the Minister. H the Minister concerned, I'll let you read it, but H the Minister concerned two cases involving citizenship where the man was the father, but he wasn't the biological father. In one, the man had sex with the woman and 30 years later discovered through DNA testing he wasn't dad. After he'd acknowledged paternity, he'd paid child support, he'd bought a house for the woman, he'd gone home to his wife and children in Melbourne and said, "Guess what I've done, darling?" And continued to pay. And in the other case, so he had raised this child as best he could long distance. And the other case was a man living in Australia, fell in love with a woman in China. She was already pregnant to someone else. And then after she gave birth, they married first and she gave birth and he puts his name on the birth certificate. So raises the child as his own. So he accepted the child as his own. And in both cases, the court said that this man is a parent. And they said about the second case, imagine if the DNA testing was the test, which Parliament hasn't said about citizenship, and then 30 years later discover that, well, in fact, you're not the parent, then citizenship would be revoked. And clearly that wasn't the intention of Parliament. You take the ordinary meaning of the word parent, and of course that changes as society changes. But there are two systems of family law in Australia. For those who are on the East Coast and think that there's only one, there's not, there's two. And that is because WA has kept powers about de factos and when we talk about property settlement, but also when we talk about children, they've kept powers about ex-nuptial children. And you've therefore got to look at the Family Court Act, the Artificial Conception Act, not the Family Law Act, if they're unmarried. If they're married and the child falls within the marriage, then the Family Law Act prevails. And recently I had a couple from WA going overseas who were unmarried, and my advice to them was get married, because it makes a considerable difference in Western Australia as the law of the moment. Because under the law of the moment, if they're married, I'm sure that they will be recognised as the parents, but under the state law, even though there's a replication of a parentage presumption under the Family Law Act, they may not be. And I just want to cover adoption, because adoption is one of those things that floats around. And here we have Section 4 of the Family Law Act that says who is a parent includes a parent of an adopted child, and who is a child includes a child who has been adopted. And adopted means, as you can see in that first dot point, if it's adopted anywhere, as long as it's in accordance with the law. Well, you may think then, well, we're a parent under the Family Law Act, so therefore there's no problem bringing the child into Australia. Wrong. You then got to navigate the migration regulations, and they can be a nightmare. And they specify certain things like you can't do a Madonna and fly somewhere else and do an adoption, get a child and come back. You won't be allowed in, even though you would be recognised under Australian law as a parent. The child won't be coming in easily. And then we have this odd situation that even though the Family Law Act casts the net wide and says, well, you do an adoption anywhere you're recognised, we have state laws that say, well, sorry about that, we may not recognise the foreign adoption. And the example is Section 105 of the New South Wales Adoption Act, which makes it quite plain, unless you fall within the ambit of this Act, the adoption is not recognised for the purpose of the law of the state. So we have this odd situation. Family Law Act says you're recognised, and yet the New South Wales Adoption Act says in some circumstances you're not. And then, of course, you have to go to Section 109 of the Commonwealth Constitution and say, well, Family Law Act prevails over the New South Wales Adoption Act. And an example is if you have a second parent adoption in the United States, which I've given, and it won't be a Hague adoption. If you do surrogacy in places like Minnesota or Iowa or Hawaii or Tennessee, for example, the biological parent will be shown to be a parent, but the non-biological parent has to be a step-parent adoption. And so that's, according to New South Wales law, not recognised, but according to the Family Law Act, recognised. And as I said to a couple of attendees in Brisbane before we started, if this stuff doesn't screw with your head, nothing will. And state and territory surrogacy orders, you may have seen some judgments if you've looked at this stuff. Family law judges tend to focus on Section 60HB of the Family Law Act that specifically recognise state parentage through state and territory surrogacy orders. And then that's taken up, the list of them is contained in Regulation 49 of the regs, and also citizenship from there is under Section 8 of the Citizenship Act. But what is often forgotten is about the basics. Section 118 of the Common Constitution, full faith and credit is given to the order, and Section 185 of the Evidence Act, the same effect. So you get an order in one state, it's going to be recognised elsewhere. And you would think, well, you got an order, for example, in Queensland, that you're the parents by surrogacy, and the child was born in Victoria, of course it's going to be recognised. And the answer, because the Constitution is quite clear about that, Family Law Act is quite clear about that, the answer is wrong. As a matter of Constitution, it's quite clear it would be recognised in Victoria, but Victoria says, well, no, if the child was born here and you got an interstate parentage order, we're not going to change the birth register, thank you very much, unless you get a registration order and you go to the county court for that, or in theory at least the Supreme Court. And you've got to convince them that, again, it's in the best interest of the child that the order is made, the very process that you've gone through in the previous proceedings, interstate. Now, the place where it happens the most is between Sydney and Melbourne. So intended parents in Sydney and the surrogates and the child was born in Melbourne. When this law was brought in, which I thought was just ridiculous, and I still think it's ridiculous, I complained to both the New South Wales and Victorian attorneys. The New South Wales attorney at the time listened, and as a result, if the child was born in Victoria, but you have a New South Wales parentage order, you go to the New South Wales Registrar of Births and Marriages and they put an entry there. So you don't have to then go to court in Melbourne afterwards. But if you're from Queensland, sorry, you've got to go to court in Melbourne. And now I'm going to turn to the Family Law Act Artificial Conception Procedure, Section 60H. 60H1 concerns a couple. 60H2 concerns a single woman. That might be the provision that DFAT look at when they think about the surrogate giving birth. And 60H3 concerns the man alone, but 60H3 has never been taken up under any prescribed law, so it's a dead letter. Section 60H has been held by the full court of the Family Court in Bernier in Dopal not to apply to surrogacy. So the rest of that case is no longer right as a matter of law, where it says you engage in surrogacy overseas, you're not recognised as parents here. But that I'm sure that they're right on that point, that it's not intended to apply to surrogacy. So Section 60H2 talks about certain prescribed laws, and I know this is being recorded, so I thought I'd do a slide on this for everyone to have a look. Here are the sections, which are very helpful. And yes, I've put Norfolk Island in yellow because I still can't believe that Norfolk Island has a status of children. And the requirements of Section 60H1, this is about a couple. First, a child is born to a woman. There hasn't yet been a case about a trans man giving birth, so that will be interesting, or someone who's non-binary, so that'll be interesting how that is interpreted. And the child must have been conceived after having an artificial conception procedure, which is artificial insemination or IVF, amongst others. And while the woman was married to a de facto partner of another, and it's called the other intended parent. There's been some case law that actually other intended parent means that they have to have intention. There's been some case law that says it's shorthand. I think it's really shorthand. Then there's an alternative test about who's the parent. The first is the couple consented and the donor consented to its use. So it's the first way you look for consent. or there's a prescribed law of a state or territory, Commonwealth state or territory. And as to the first one, well, when do they have to be together? Was it at the time of the implantation or at the time of birth? And as far as I know, there's no appellate decision. The two leading decisions, Keaton and Aldridge and Wickham and Toledano, I was in the second case. We had a case involving about whether the two women were in a de facto relationship on the day in question. I was for the sister and sister-in-law of the woman who gave birth. She died 3 days after giving birth to twins. And my clients ran the line that, yes, there was a relationship of some kind between her and the other woman, but we don't believe it occurred on the day of implantation. We were able to prove, despite the woman having died, that there was not a de facto relationship on that day. Justice Carew took the view, when she read the section, it could be either of these days at the time of the artificial conception procedure or birth, and all the counsel for three parties said it's at the time of conception, and she ultimately said that's right. And if you're relying on the second limb, well, here are the various sections. Again, because this is being recorded, you'll be able to see this. I mentioned Crisp and Clarence. When it got to the full court, it's called Clarence and Crisp. I was for the birth mother in that case. We had the misfortune that the implantation occurred in Queensland, but the child had moved to South Australia. So when you're looking at this section, we had to look at the Family Relationships Act in South Australia and the Status of Children Act in Queensland, and they didn't quite align. So just be aware of it, that you may think that they're identical, but they may not be. If you can get under the first limb of Section 60H1, always try the first limb, because you're going to the second limb, which law applies. And you can spend time and resources arguing that point, all very interesting to you, but not so much to your client. But there's no saying about what is consent. The Act doesn't prescribe it, and the state acts don't prescribe it. But there is this useful decision from 3 years ago from the Court of Appeal in England, where there is a presumption for lesbian couples that there isn't consent. And I'll just let you read this, but you can see, well, consent's a matter of fact, or no consent. It's when the procedure occurred, but look before and after so you can work out what was actually happening. And because it's not prescribed, it could be oral. And so you could have, if we give that example again of a lesbian couple, where one woman goes to the clinic and gets treatment and the other one stays at home, the other might have consented. So even though she hasn't filled out the form for the IVF clinic, she might have consented. Of course, consent and the section also applies to at-home insemination. And of course, we don't have a form for that. And there may not have been communication about consent. So I thought this was a very interesting case, and giving a shopping list, very helpful. If you look at this particular circumstance, and just after this case came out, I had two cases that I had to give advice on where it was alleged that one of the women had undertaken the treatment and the other woman said, I'm also a parent, even though she had not gone to the clinic, had not taken part in counselling, had not signed any consent forms with the clinic. And of course, acquiescence isn't consent, but you have to work out what are we looking at here. Is it really acquiescence? You know, I'm letting my partner go through it, or is it in fact consent? And of course, it makes a big difference. If you're for the other alleged parent, they may want to be a parent, but everything that flows from that. On the other hand, they might say, no, I don't want to be a parent. I don't want 18 years of child support. Thank you very much. But it can make such a difference. So I think we'll probably keep moving because I'm conscious of time. And we have state laws that talk about female couples. But as you can see in the red on the right, they haven't been updated since the 2017 changes to the Marriage Act. So Norfolk Island, Northern Territory, Queensland and WA, although WA is soon to go, the only relationship that is recognised for women is when they're in a de facto relationship. And you might say, well, I'm a family lawyer, I look at the Family Law Act. Great. But when you're dealing with births, deaths and marriages, the first act that they want to look at is their state act. You might say, well, High Court has said, look at the Family Law Act first. No, they want to look at the State Act first, and then you take them to the Family Law Act second. So just a tip. Family Law Act has parentage presumptions, and these are all rebuttable. And the classic example, 69P, wife gets pregnant, but it was from having sex with the neighbour, not with her husband. And so you can rebut it. Based on that evidence. And one that's really stood out now is 69R, parentage from birth registration. And that's because of changes that happened on April Fool's Day last year with the commencement of the 2024 Family Law Regulations, which I hope is the next slide. So if we go back a decade, if you had a child born overseas, it was hard to prove whether who was a parent of that child for purposes of the Family Law Act. Some judges said the child born by surrogacy, yes, you're a parent. Another judge said, no, you're not. Other judges said, not sure. One unfortunate couple had two separate applications because they had more than one child. And one judge says, yes, you're the parents. The other judge says, no, you're not. And I'm referring you to authorities for engaging in surrogacy overseas. And the circumstances for each journey were identical, so wholly unsatisfactory. So I devised a method of registering overseas surrogacy orders under the Family Law Act, and a number of those came before the Family Court. I got up on some and went down on others, the court being concerned about whether it's commercial surrogacy or not, but that would have got round the problem. Now, you can't, it's very hard to do that, at least through the court. What you'll be doing is the administrative process through Attorney Generals in Canberra and then through the court registry. But many overseas jurisdictions now prescribe for the parentage provision. So if you look at a birth certificate and it shows mum and dad, or mum or dad and dad, two mums, then go to Schedules 2 and 4 of the Family Law Regs to see whether they are prescribed overseas jurisdictions, because if they are, then lo and behold, they are presumed to be the parents. And these are the kind of countries, India's in there, as you can see, but the ones I've put in yellow are current places where Australians have done surrogacy. They've also done other places like South Africa, Israel, Malaysia. But these are the common countries, and the most common at the moment are the US in this list, US, Mexico, Canada, and Colombia. But because they'll be on the birth certificate, therefore they're recognised. They're presumed to be the parents under Section 69R. This is a decision from a month ago by Judge Harland in Melbourne. This gay couple underwent surrogacy in the US. They got a court order, they got a birth certificate saying that they were the parents. And it's no surprise that Her Honour then said, well, look at the statutory scheme, 69R, Section 102 of the Act concerning birth certificate, Reg 10 and Schedule 2, and lo and behold, you are the parents, and then made the declaration. Very useful that Her Honour made that point about kids being born of surrogacy being discriminated against. The big case in family law dealing with kids is this case of Masson and Parsons, and it took the same approach that the federal court had taken in H. the Minister. It's a question of fact. And that question of fact of parentage applies when there's no other specific provision of the Family Law Act under Part 7 of the Family Law Act. Part 7 overrides any conflicting state or territory law. The court said, well, the door was open, in effect, to being argued about whether there might be more than two parents. was argued by and it wasn't a surrogacy case, it was a man who provided sperm to a lesbian friend so they could be parents together. He ended up in the birth certificate. The court found that he was a parent because he supplied his sperm and expressed or implied understanding to be a parent, and he then put his name on the birth certificate to be a parent and that he parented. But if, on the other hand, he supplied his sperm not to do any of those things, then clearly it had nothing to do with the child. Clearly, he was not a parent. So intention is relevant about who is a parent. And that makes it quite difficult when you're dealing with sperm donors, because a sperm donor may be a parent or not a parent, depending on intention. And it's important that sperm donors have written agreements that set this out. The two words that stood out to me in Masson was express or implied, or rather the two words are or implied. I said three words. But why I say those two words are important is because it's clear that the agreement in Masson was oral. If it were expressed, it would have been said on the document. You wouldn't have to say implied. These three cases are authority that the biological intended parent through surrogacy is a parent. Cedo and Poon was a case between Southeast Asia and New South Wales. Tickner and Rodder was a New South Wales surrogacy arrangement that went awry. Gallo and Ruiz was an international commercial surrogacy arrangement. But these two cases say, well, not a parent. Lloyd and Compton was the case that was in the news where Justice Carew referred the Queensland couple to authorities for engaging in commercial surrogacy in North Cyprus, and ultimately they weren't charged. And in both cases, the judges say, you haven't come to us arguing the fundamental jurisdictional point about standing. And in both cases, they said, what's the impact of Masson? They didn't know, and they weren't highlighted according to the judgments about Cedo, Tickner or Gallo, although Cedo is referred in Lloyd and Compton on another point. But the result was that you're not a parent under Section 60HB because you haven't got a parentage order in a state and territory court, but didn't look at the concept more widely about, on the facts of this case, is there a parent? But as a result, we had these two different approaches about people who've done surrogacy somewhere else. But then we have these two cases, single judge decision of Mitsushima and Crucetti number 3, and then the full court decision of Ophover and Bassina. Look at the whole of the circumstances. And in Ophover, we have this comment of the divorce between biological parentage and who is in fact a parent. So you've got to look at that. And the reference to Baroness Hale, this was a reference taken up by the High Court of Masson and Parsons, which is who is a social and psychological parent? Someone who sees themselves as a parent, even if they're not a biological parent. And although the Family Law Act talks about both parents, and Masson has given the hint there might be more than two, Ophover is here saying clearly, at least in theory, there could be more than two. And we've had a number of cases where gay and lesbian couples together have created a child. And you'd certainly say that the guy who provides his sperm to the lesbian couple under Section 60H1 is not a parent. But what about the other bloke? He might be, because he might be the social and psychological parent. So that's where we are at currently with law, and it'll be interesting to see how it develops. The plurality in Ophover said these are the things that made the primary judge, I should say, which the plurality accepted, these are the things that made this bloke daddy. And I'll let you read them, but you can see this. Quite a few. But here she is, she come back from overseas. I'll give you the choice if you want to be a father to the baby and form a family together, or I'll bring the baby up on my own. And he said, I want to be a father. I think that was the critical moment that then made him dad. But they went to a baby intensive course together. They decided to live together immediately following the birth. he turned up at the birth. Well, that's always sort of a pretty good sign that he wants to be dad, one would think. They put themselves on the birth certificate as the parents. They lived together from the time of the birth of the child until the child was about 3. And then she writes to him a message about wanting time, but then held back on it until he went to court and got some. And by the time they got to court, at trial, this case had been going for 5 years, which is pretty depressing. But there he was. He'd been playing the role of dad for all that time. And lo and behold, the child, of course, said, well, you're daddy. Mummy and daddy, this is my family. Justice Gill, on the other hand, put a lot more focus on biology. He said, every case is different, you've got to look at the facts, but biology isn't always the end point. But if you have an absence of biology, timing is critical. I'll put those bits in yellow because I think that's the difference between His Honour and the other 2 judges. Namely, she was already pregnant when she said to him, do you want to be dad? And he says, yes, I want to be dad. Whereas I think Justice Gill was emphasising, well, it should have happened before she got pregnant, that's the relevant intention. And His Honour then made this comment about the significance of who's parent. And of course, the last paragraph is really saying, oh, here we are engaging in social engineering again. That's really what I read by that comment. And yeah, you might think, okay, well, that's as far as we're going to go, but look at this case. Bron and Torleaf, Aboriginal child living in a remote community. The child lived with Miss Bron. She wasn't Aboriginal. We've got a mother and a father. They were pretty hopeless in terms of their parenting capacity and didn't have much to do with the child. And we have this other person, Miss Tracy, who was a cousin of the mother. And the judge was sort of leaving open there the possibility of a submission that Ms. Tracy or Ms. Fron might be a social and psychological parent. But then said, well, no one addressed me. You can just see, I can just see the doors opening there that someone can say that. You go, how could that be the case? We've got a child naturally conceived, we've got a father and a mother, and we've got these floating around. But that's where we seem to be heading. So we'll see where that goes. And then finally, I'm conscious of time. If you have a child through sex, are you still dad? And the leading case is this case of ND and BM, where a man was in a relationship with a woman, and then one day she says, I'm bisexual. And then they separate, and lo and behold, she has a girlfriend, so she moves in with her female partner, and then they go back to him and say, we'd like to have a child. And how we'd like to have a child is for you to have sex. Can't remember whether it's with her or the other woman. But we agree that we will be the parents and you won't be a parent. So that's before the current iteration of Section 60H. But of course, the child was conceived natural. Well, that all worked well until the women split up. And then, of course, he got the demand to pay child support. And he said, well, but what about intention? The whole agreement was that I wasn't going to be a parent. And the judge said, well, intention's irrelevant because you're a parent and tough luck, you have to pay. So what's not clear in light of the High Court decision in Masson from 2019 is if you're having sex these days and you conceive a child, are you a parent? And the answer is, I don't know. There's certainly overseas cases where men have had sex with their former partners. There's one from South Africa and one from Canada, where in one case he wanted to be a parent, And the judge said, yes, you are. And the other, where it was quite clear he didn't want to be a parent, and the judge says, no, you're not. So they look at the intention. But certainly one of the things we are seeing in Australian society at the moment are that there are many known sperm donors, and many of them put the letters NI beside their name for natural insemination because they want to have sex. Are they going to be parents, or have they become parents when they've had a child? Answer, I don't know. I don't know. And that's it.
Oh, well, thank you, Stephen. What an insightful presentation, and very detailed. Thank you. I'll just check if anybody has any questions. They're welcome to pop it in the chat box. Stephen will be more than happy to answer any of those. Otherwise, if there are no questions, we will send through a summary of this presentation to the registered attendees. As mentioned, this has been recorded. Oh, we do have a question, sorry. Got a few now.
Okay, good.
All right,
excellent.
Let's go through the questions. Okay. Oh, wait. The sitting chat is disabled. Please bear with me, everybody. It seems that the chat has been disabled. So if you can try now. I have just tried enabling the chat now. Okay, great. So first question, any cases where dad is biological dad using overseas surrogates, then donor mum comes in later trying to access?
So the donor mum, okay. No, I've never seen that. That's always a worry that the surrogate might say, well, I'm a parent and therefore I'm going to try and take the child back and rely on Hague, or the donor might do that. Most donation that occurs overseas is anonymous, but in any case, there's typically agreements that say nothing to do with the child, will not be a parent, that the intended parents are the parents.
Great. Any other questions? Got some feedback about this is all a little bit more complicated than some had imagined. So it does definitely sound very complex.
Yeah, it is. It's certainly a very complex area, and what I've seen in previous presentations, I've run a number of these seminars where I've asked family lawyers, specialist family lawyers, to take a punt on who is a parent here, yes or no. And it surprised me that so many get it wrong. And that's not having a go at them, it's just a specialty. So if in doubt, ask. Because there is really some fine print here, and as we know, the law plays catch up with how society is streaking ahead. Society is streaking well and truly ahead here of where the law is at.
Yeah, good point.
I just got a question. Like, is there any aspect of this where, like, the views of, like, the child might be taken into account, like who the child would identify as mummy or not mummy, daddy or not daddy?
Yeah. So I've been asked, in case anyone didn't hear it, is the view of the child taken into account as to who is the parent? And the answer is, I suppose, it can be, but often the determination is made before then, when the child is a baby.
Yeah.
So the child isn't in a position to say who is a parent. What I have been surprised at is that I've had a number of cases where lesbians have had a child together, and the non-biological mother, so the law is quite clear under Section 68(1), she's a parent, has said, they split up, and she says, I don't consider myself to be a parent. And in those circumstances, the other mother hasn't pressed child support because in some cases they have, but in other cases they haven't pressed child support because, well, if you're not interested, you're not interested. There's no point of pressing it. There's no biological connection between that woman and the child. If she's not interested, why go there?
Okay. Thanks, Amy. We have another question. The recent Monash IVF mix-up, do you foresee application of the third category potentially?
So third category of? The recent Monash IVF mix-up, we've had two Monash IVF mix-ups, unfortunately, but I assume the one that you're talking about is where Baroness Hale's considerations. Well, if we look at what happened, embryologists got the wrong embryo and they used it from one couple to another couple, and then the other couple then had a child. Well, because they had a child, therefore they presumably registered the birth of the child. They're shown on the birth certificate as the parents. Therefore, under Section 69R, Family Law Act, and 69T, in respect to the father, the acknowledgement of paternity, are presumed to be the parents. It's really as simple as that.
Okay, and then there's one more here. How does the law apply to polyamorous relationships?
That's a very good question. The answer is we're still watching that. To give an example, I had a sperm donor agreement from a year or so back with a lesbian couple and a known sperm donor. Now, you'd say 60H, they're the parents. The problem is that he would be a person concerned with the care, welfare and development of the child under 65C of the Family Law Act and could therefore litigate. But what if he's in a relationship with others? Now, he was part of a male throuple. So there's three of them living under the one roof. I took the view that all five parties should be a party to the sperm donor agreement, and all five parties should also take part in fertility counselling, so that it's quite clear that the other two blokes did not have an intention to become parents, and there was clear evidence that of that.
That's it. Okay, I think that's all of the questions now. Thank you, everybody, for joining, and a big thank you for your wonderful presentation, Stephen.
Thank you, Kristen. Thank you, everyone.
Much appreciated. Have a great day, everybody.
See you all. Bye-bye. Aren't you glad you stayed for that? Here's your head.